Good afternoon. I'm your host, Brian Buckmire, here at the Law and Crime Report. We're going to begin the story in Oregon, where there's a lot of changes that happened just yesterday in the ballot box. Now, they've decriminalized a large amount of drugs that have been on the books for quite some time. We're talking cocaine, heroin. And what I mean by decriminalizing, those have moved for being what it might have been a misdemeanor or a felony down to what they refer to as an E-class violation. Now, if you're caught with these drugs in terms of single use, so we're not talking about pounds or ounces or kilos, but single use, a small amount, you would still be arrested and can be fined up to $100 and also be put into a drug rehabilitation program. Now, that program is being funded through Oregon's legal marijuana use or industry in that state. Let's bring in our guests and let's talk about the decriminalization of drugs in Oregon and other states actually as well. Let's start off with Gene Rossi, Mike Koribanics, and Gigi Gonzalez. Good afternoon to you both.
Good afternoon.
Good afternoon.
To you all, sorry. So Mike, let's come to you first. We're seeing that drugs are having a different legal standard in the state of Oregon. How do you see this move coming about? They're taking this step towards this kind of quote-unquote war on drugs that happened in the 70s and reevaluating it in a different way. What do you make of this move?
I think, as being a former prosecutor and defense attorney, that it is a move in the right direction. We have seen that punishing people who have addictions really gets us nowhere. I think this is a very positive move, and I think it's a move that's not saying, hey, everybody go out and party. It's saying those who are caught with small amount of drugs, not those selling it, not those doing other things with it, but those who are really already imprisoned by their own addictions, we're going to help you. We're going to give you a chance. We're going to try to make you better by putting you through rehab. As we all know, you can't keep somebody in prison and beat their addiction. It is a long process. It takes steps, and it really doesn't ever occur till that person decides they want help. But to really, someone who's suffering an addiction, give them a criminal conviction that could ruin the rest of their life and prevent them from getting better, we've learned is really not the best way. And I think this is a move in the right direction.
Now, Gigi, I'm not sure about you in Miami. I know, interesting enough, we're all in different parts of the country, different states, but I know in some places in New Jersey, in some places in New York, Brooklyn, for example, we've already kind of done this in terms of practice. We might not have it on the books, but if you're caught with a little bit of cocaine or a little bit of heroin, most courts are moving you into drug treatment programs, drug treatment facilities, and not really looking to knock you over the head with that year in jail that's on the books. Do you see this as just moving in line with what so many other counties and states have been doing already, but just solidifying on the books?
Yes, the trend towards convicting those with personal uses of cocaine, heroin, meth is definitely going away. As Mike Koribanics so eloquently put it, this isn't the best way to rehabilitate these types of people. People with addictions are not going to be rehabilitated by throwing prison sentences at them. And I think Oregon has really set a really great standard of how we go about dealing with these types of cases. I think it's wonderful that you're imposing a fine that's going to be hurt, but not completely stifle somebody, and you're promoting a recovery program that they have to attend in order to resolve this case. You're going to see positive benefits both in the prison population. You're going to see a decrease in the prison population. You're going to see recidivism rates with people that are not going to be reoffending because they're getting the proper treatment for these types of cases. When usually over and over in the past, what we've seen is these types of people get charged with possession and possession and possession until they're spending the rest of their time in prison and they're not getting the treatment that they need or deserve. And I think that Oregon is doing a really great job at setting the standard for the rest of the country.
Yeah, and maybe more will follow. Gene Rossi, the elephants in the room. What about the feds? Because Oregon can do whatever it wants, but the federal government is going to say this is a Schedule I drug. Sure, you hippies might think that marijuana is fun, and that's an argument we're going to have. But now we're talking cocaine, heroin, and on top of that, Oregon is going one step further, and they're legalizing the therapeutic use of a drug that's actually found in magic mushrooms. The FDA has granted a quote-unquote breakthrough therapy status for it to help with depression and anxiety. Sure, there are medical benefits to it, but on the books, the feds are saying Schedule I drug. So how are we going to work this out?
Well, under Title 21, Section 841, you could be prosecuted for felony possession with intent to distribute. And then Section 844 is felony possession itself. But what I want to say about this is the feds are not going to go near these cases because they got other fish to fry. I was a prosecutor with the U.S. Attorney's Office for over 20 years. And I learned this because I did a lot of drug cases, especially oxy cases. Addiction is a disease, and mass incarceration is not the cure. And as someone who had cancer and almost died, I know what the hell a cure is. So this is a great law because it attacks the disease and not necessarily the crime. These individuals who have these addictions, they can't control themselves. And to put them in prison is just an incredibly irrational thing to do.
It's going to be interesting to see how that plays out. I hope that Oregon has got all their T's crossed and their I's dotted, and so the rest of the country can look to that as an example and hopefully expand this concept to other states. Let's switch gears now and continuing with our topics of the federal government. The NAACP and the ACLU both have filed lawsuits based on the response out of Graham, North Carolina. And that is where officers are being accused of using pepper spray to disperse a peaceful protest or rally by the name of I Am Change, advocating for those to use their voice to vote. Let's take a listen to the Lieutenant Daniel Sis describing how the event actually occurred.
Towards the conclusion of the event, the sheriff's office had interaction with people in the rally that led to people coming out into the streets. When we tried to prevent people from being in the streets at that point, one of our officers was assaulted. And at that point, that's when we deemed that it was an unsafe event and deemed that it was unlawful, and we went ahead and dispersed the crowd. The disbursement measures we used was using a pepper fogger that was never directed at any person. We directed it towards the ground. That created a vapor that kind of just went into the air as an irritant. Our officers were never ordered to don masks or anything like that, so they suffered the same effects of it as well. It's a mild irritant, and we chose to use that rather than physical force to get people moved out of the roadway. I understand that some people were saying that we pepper spray children and disabled folks. Again, I'm going to reiterate, we never directly sprayed anyone in the face. It was all directed towards the ground in an effort to disperse the crowd. The initial disbursement was after they made it to Court Square. We allowed them to pause for 8 minutes and 40-some seconds. And after about 9 minutes, told them they needed to clear the road. Once it was clear that they had no intention to clear the road, we sprayed a couple sprays on the ground, and the crowds moved to the respective areas where they were at.
All right, that's officially what the officers are saying that they did, and there are plenty of video and photos that you can look up and definitely check out for yourself. From the NAACP and the ACLU standpoint, they're saying that these actions were used to suppress and violently used to suppress the peaceful assembly gathered for the express purpose of encouraging people to vote. From their view, the officers used that pepper spray for two actual actions. One that the officer there was describing, but also to disperse people from the road after a moment of silence. Let's bring in our guest again, Gigi Gonzalez. The suits are coming forward, okay? The video's out there, the photos are there. But what do you make of this suit, and do you think it has any way of going further for the NAACP and the ACLU and the people they're representing?
Yes, absolutely. I think there's a definite path to victory for the ACLU and the NAACP in this matter. If this protest was organized and if they got the proper permits, it's going to be really hard for the police to make the defense that they were dispersing an unlawful or an unsafe protest. From the videos and photos that I've seen, it appears to be a very peaceful event. And not only that, this is an event designed to get people to the polls. So it's really hard to imagine why the police would use tear gas. I don't care if they pointed it at the ground near protesters or directly near protesters. They used pepper spray on the people protesting or marching to vote. You have to wonder, what is your motivation if there's clearly no unlawful activity taking place? Clearly it's a safe event. Why are you using tear gas to prevent people from making it to the polls? It's probably to suppress their vote.
Yeah, and Gina, I want to ask you about that too, because we've seen police officers use use of force in varying ways to disperse crowds, whether you're talking about Black Lives Matters, Trump supporters, different political issues that people are protesting. But this one just rings a little different because we're talking about voting. Is the fact that the narrative is a little bit different and we're talking not about a political issue between one side or the other, but just something that I think we all can agree with, people should go out and vote. Does that change the calculus in any way, shape, or form?
I think it does, and I'll tell you why. Under 18 U.S.C. 242, it's the civil rights statute for a willful violation of someone's constitutional rights, or if there's a police shooting, which we didn't have. But if they are taking actions to interfere with the constitutional right, i.e. freedom of expression under the First Amendment, and they're doing it willfully without any objective standard for taking those actions, then they could be liable, okay, criminally and civilly. But I do want to ask a few questions here because I haven't seen the entire video. Did they give these did they give these individuals a warning that they were violating some local ordinance or something like that? Did they give them a clear warning? That's the first thing I would ask. Number two, this whole thing about the pepper spray were not aimed at the faces. Okay, that dog won't hunt, all right? You don't have to shoot pepper spray at someone's face to get it on their face. If you just put it near them, it spreads like a vapor. Okay, it's like gasoline. You don't have to have it on you, but you could get it on you by the vapors. So that argument doesn't hold any water. And the last thing I want to know is this. Looking at that photos and the videos, I don't see any officer assaulted. So I'd like to know the phantom officer who was assaulted. If there was an officer assaulted, that would inure and help the police who may be charged in this case.
Yeah. A lot of great questions to ask. You took my question about the dog, and I was going to actually ask Mike Koribanics if that dog would hunt, but you took it already. We're going to take a quick break, and we'll be back with more here at the Law and Crime Report. Welcome back. We continue our coverage by going to Louisiana, where Holden Matthews was sentenced to 300 months. And if you're doing the math, that's 25 years in prison, along with 3 years of supervised release afterwards, and to pay restitution of $2.6 million for burning 3 predominantly and historically black churches. Some of these churches have been here for over 150 years, standing the test of time, but were burned to a crisp because of this defendant. Now, let's listen to the Louisiana governor speaking more about the crimes.
Nobody should ever fear for safety in their house of worship or fear that their church will be destroyed. I don't know what this young man's motive was. I don't know what was in his heart, but I can say it cannot be justified or rationalized. These were evil acts. But let me be clear about this. Hate is not a Louisiana value, and violence has no place in our communities. We are better than this, and this is a reflection of one depraved individual. It is not a reflection on the state of Louisiana, and I am extremely confident that I am 100% correct when I say that. And while I hope that justice will restore some peace of mind to the members of this community, I also realize that it's going to take time to recover, both physically and emotionally, from the damage that has been done. But in the words of Psalm 62, God is our fortress, and we will never be shaken. So I would ask that everyone listening to this press conference join me in praying for healing and restoration. Let's pray for the congregations in this Lenten season. Let's make sure that they all have a place to worship on Palm Sunday and then Easter Sunday. And by the way, let's pray for Mr. Matthews and his family. That God will create in him, in all of us, but in him at this time, a clean heart.
All right, so just a little bit of background, because in the pleading, we did find out about the motivations of Holden Matthews. Now, the incidents occurred on March 26th of 2019. That was last year, not too long ago. And our understanding is, and I had to do a little research on this, he's a part of what's called the black metal community. It's an extreme subgenre of heavy metal music. And he was actually attempting to do these actions being that of burning the churches, to gain notoriety. He seemed to be impersonating or showing off to others in his community, and he actually posted photos on Facebook of the 2 first fires before going to the 3rd. He also said there is not enough words in the English language to say how sorry he is, and ironically for me, he said if he could go back and change it, he would. Not only because he hurt his family and his friends, but he also hurt his brothers and sisters in Christ. Mike Koribanics, help me out here. I've been to plenty of Sunday church events, Catholic school for the most of my life. He's now worried about his brothers and sisters in Christ after setting fire to 3 churches? I must have missed that part of Bible school.
Well, that part of Bible school usually comes out just before the judge puts a sentence on you with defendants who have caused such heinous crimes. Because to be there, I don't really, listen, I hope it's true. I'm very skeptical about whether or not he feels that from his heart. There's nothing more reckless in our crimes than arson, starting of fires, because they become so out of control. You don't know who's in the building. You don't know if there's anyone in the building. You don't know where it could spread. They are just horrible, vicious, and reckless acts. And the motivation here and the driving of this defendant is scary. It is very scary.
Yeah. And Gene Rossi, just historically speaking, some of these churches trace their origins back to the Reconstruction period after the Civil War. The things that these churches survived, the people who went there for shelter, and now burn because you want to be a little bit more popular in your music genre. What are some of your thoughts on this?
I think he was very lucky that he got just 25 years. I can tell you this right now, at the Eastern District of Virginia, he probably would have gotten close to life. And the reason is this: it wasn't just one church. That's horrible enough. It's 3 churches. And number 2, did he focus on these particular churches? Or did you just drive down the street, see a cross, and say, hey, there's a church, I want to blow it up or burn it down? If he focused on that church because of its historical nature and it was African American or a certain religion or race, then that raises the bar for the sentencing in my book. So going back, the punchline for me is he's lucky he got 25 years, and the defense attorney should get a medal.
Yeah. And Gigi, let's talk about that. There's no hate crime based on either religion or race, and it's only 25 years. When you hear all the facts as they parsed out, 25 years, is he really lucky, or did the prosecutor not go far enough? What are some of your thoughts?
Well, I think the prosecutor... Oh, I'm sorry.
Oh, Gigi.
I apologize.
I thought you said Gigi. Gigi. Hey, Gigi, you got to change your name.
I'm going to take it over. Okay. I think that he really made it out here well with 25 years. You know, he's facing 70. He doesn't appear, he did this for clout, right? He did this to impress the heavy metal, black metal community. You know, so it was reckless. His targeting of these historic churches was reckless. He was facing 70 years, and at the end of the day, he accepted responsibility. He pled guilty. He asked for remorse. He told the court and the victims how sorry he was, and he wished he could take it back. Now, whether we believe it or not is another thing, and maybe he'll become a born again Christian in prison, and he will go on to, you know, speak of powerfully against these types of acts in the future. I don't know. I sure hope so, but I think that he really did make out well, and by accepting responsibility for his actions, he was able to avoid a much stiffer sentence if he had gone to trial on this.
Right. Let's switch gears now to LSU, where a tragic story could have been far worse for pledges in a university's fraternity. I'm talking about Phi Kappa Psi, where the member by the name of Terry Pat Reynolds II is being prosecuted for 1 count of felony hazing, as well as 12 counts of misdemeanor hazing. Now, to understand this story fully, I think we've got to step back just 3 years, because 3 years in LSU, Maxwell Groover died under similar circumstances. And let's listen to the parents of Maxwell Groover, who spoke about this in an interview about how devastating this hazing affected their family.
Was your son murdered?
Yes, I believe so. Nobody can physically drink that much. You can't. You have to be forced to drink it. It's senseless.
It's terrible.
I mean, how is making your brother do all these things and humiliating somebody a brotherhood?
Now, I think it's fair to say we've all been to college here on the Law and Crime Network. As I talk to you, Gene, Gigi, and Mike, this one to me, especially as a former athlete, always hits really hard. I was in college not too long ago, and we heard countless stories about this, especially in the athletic department, that hazing was not to be done. You couldn't even ask a freshman to carry the soccer balls, and I'm saying that because I played soccer, to carry the soccer balls because they're a freshman. So to hear that this is still going on after years and years of us hearing these tragic stories is absolutely heartbreaking. I'm glad no one died. But Gene, let's start with you. Hazing still happening after us seeing so many people die, so many people harmed. What do you make of this story?
Well, I laid blame actually on the administration of LSU because they are condoning. There is no way that the leaders at LSU do not know that these fraternities are still doing this. I don't think sororities do it, but maybe they do. But if they do, they shouldn't. But these fraternities, when they have these parties and they do these hazings, word travels like wildfire on a college campus, period. End of story. No argument. So when these fraternities have these hazing parties, I'm sure that leaders on the campus of LSU know about it and they are condoning it. I don't want to be facetious. I always think about the movie Animal House, all right? And Dean Wormer, okay? They know what's going on. And I lay the blame there because they need to take action. And here's the action. If they hear of this, even by rumor, the license or the rights of that fraternity should be suspended for 2 or 3 years. Game over.
Yeah, but unfortunately, even I remember, Gene, that would happen. And then 2 or 3 years later, as we are here at LSU, 2 or 3 years later, after Maxwell Groover, we seem to be having this conversation again. So I guess the question becomes, what do we do instead of these 2 to 3 year suspensions? Gigi Gonzalez, we heard about this story because the investigation started back in October 19th. Oftentimes, these hazing events happen at the beginning of the year so they can join the frat or the sorority. The victim was dropped off at the hospital, was unresponsive, was given life-saving treatment. They had to be put on life support because they had drunk so much. What are we to do with this type of thing? Because we've got to stop this in some way, shape, or form. What was your first reaction when you heard the story?
Yeah, the first reaction I had was frustration. You know, we see this all the time. Whenever you see a Greek organization in the headlines, it's because they took things too far with their new members or their pledge members. You know, there's no reason that anybody can think of, any reasonable reason, to stick in a room a bunch of 18-year-olds and force them to drink gallons and gallons of alcohol. You know, what benefit do you get from that? How does that promote the organization in a positive way? And for it to be happening so blatantly, and to go to Gene's Animal House reference, too often these Greek organizations go on double secret probation, where it's just falling under the wavelengths of administration. And then administrators know what they're doing, but they don't want to take responsibility for it. And because they think that they already impose these restrictions on these Greek organizations, it's not going to happen again. And here we are, and it's happening again. It's very frustrating, and I feel for the victim here. His blood alcohol content was 0.451. He had pink foam sloshing from his mouth, indicating intense organ failure. You know, there is absolutely no reason to subject anybody to that.
Yeah, and Mike Koribanics, we as defense attorneys are very familiar with the blood alcohol content concept. You and I, pretty big guys, we can probably put back 3 beers, and our blood alcohol content would probably be like 0.08, like 0.09, like we wouldn't be able to drive. So when you hear the number 0.4, what comes to your mind as to alcohol consumption for that victim?
Death. You're very lucky you're not dead at that time. You're over 3 times the legal limit.
Right.
And the big part of this is, I think these universities have to educate. They have to get the elitist type of thing that goes along with a fraternity. And, you know, we all here on this panel do criminal defense work or have been in prosecutions or things of that nature. And the problem is everybody thinks this can't happen. We deal every day, and our normal day is all the things that people think can happen. So this, I think, is much more prevalent. And I think colleges, as Gene pointed out, need to be more hands-on and not allow this to go. If they're going to associate with the university should educate and monitor so this doesn't happen again. Times are changing.
Yeah. And true education. I'm sorry, I'm not a big fan of just saying don't drink till you're 21. Educate until they get to that age so they know how to do it properly. I've got 20-year-old siblings. That's the only way to do it. Abstinence, I don't think really works here. Proper education is what's needed. We're going to take a quick break and come back with more here, the Law and Crime Report. $723 years. That is not an error. That is how much time Lisa Marie Lesher was sentenced for her charges of abuse of two children, her daughter and her stepdaughter. Her husband, Michael William Lesher, a little bit better off, but still got 438 years. Now, let's bring in our guests and let's talk about this because these are numbers I have never heard of. I know we've always talked about, hey, the judge can really bang you over the head and consec these charges as the judge did here. But we're talking about over a millennia of years between two defendants. Gene Rossi, let's start with you. Just from a numbers game, talk to me about how serious it is when you hear 723 years and your co-defendant saying, well, I got 438, so I guess I got a deal. What do you think about those numbers?
In a sick way, I'd rather get sentenced to life. I'm serious, than to have a sentence with 400 to 700 years. That just is beyond. And I assume there's no parole or good time. So when you get a sentence like that, it says one thing about the judge. These crimes were egregious, they were horrendous, and the judge just said, you know what? You have no redeeming social value. You have forfeited your right to be on this earth. You're lucky you didn't get the death penalty. That's what that says to me.
Yeah, and I don't think anyone will disagree. Wow, I'm stumbling at these numbers because they're so huge. My Koribanics, we're talking about serious charges here and the most vulnerable of victims. We're talking about first-degree rape, sexual torture, first-degree sodomy of young children over the course of several years. These children were living in hell. I don't use that as a term of art, but if there's hell on earth, I would imagine that's what it would be. It's hard for me to say this, but do you think that maybe the time fits the crime, even though it's an astronomically large number?
Absolutely. And I agree with what Gene said. I think the judge was sending out a message. We hear the word life so often, unfortunately, in a lot of sentencings, that it really doesn't ring of anything. But look at the discussion 723 and 438 or 43, whatever the other sentence were. That really hits home and lets people know how serious and egregious this was. When you use life, it's almost become a term where people see it in the newspaper and move on or hear it on the news. But these numbers really make you think, and I think the judge really sent the message out of how horrific these crimes were.
Yeah, I think it was a message. I think it was well heard. I think it was properly received. But again, those numbers, I just want to say it again, 723 and 438. The Leshers will not see the light of day for the charges and crimes they've committed. Let's switch gears and talk about now the case that we've been following in the closing arguments in the Martin case. That is a former Tampa Bay Ray baseball player who was accused of murdering his father, his uncle, and an ADT technician who was home at the time installing a security system, hopefully to try to protect that family, but unfortunately was not able to. Let's take a listen to some of the prosecution's closing arguments in that case.
You heard from Mr. Aguino, blood spatter expert. He told you that these men suffered multiple blows, and you could tell from the location of the blood spatter where this happened. And you know from that blood spatter that Ricky Anderson was hit when he was upright, and then when he fell to the floor, having been hit once or twice in his head, as he was 2 to 3 inches from that wood floor. The defendant hit him again and again. from Mr. Barry Swanson, you know, in that kitchen island, there are two distinct locations where there was blood spatter showing that he had been hit multiple times with that baseball bat. You'll see at the top of the island, there was one spot, and then another spot that was by the pantry door. And by that pantry door, we have blood spatter, and we also had on the side of the wall, the smearing, which is where Barry Swanson, having been beaten with that bat, was trying to gain some position where he could stand to his feet, and that's where you have that blood smear on the wall. And then with Michael Martin, sitting in that chair, waiting and waiting for the inevitable fact that he too is going to suffer a painful death at the hands of his own son. Multiple blows. And Dr. Schumann told you those multiple blows resulted in multiple fractures. And remember, these fractures, and you saw the photographs to the head, and you can ask for those skulls, which will give you a 3D understanding of the depression of the cracked cranium of these individuals. But to understand the force and duration, to understand the premeditation and deliberation, you can see that each one of these powerful blows from a professional ball player to the head, they're to the head, intent to kill. There's only one thing the defendant had in his mind at that time, was that he had weighed the consequences and considered his actions, and he decided to kill and then kill. And he did that by aiming at the head. You see, with Ricky Anderson had no defensive wounds. There were no strike marks to his body. He had no time to defend himself. The first strike was to the back of his head, just behind that left ear. And then he was struck in the throat. And as we just heard, as he went to the ground, he was struck again and again.
Gigi Gonzalez, this was by all accounts, and I don't mean it facetiously, a bloody mess. There were some victims who you couldn't even tell their race or ethnicity or who they were based on the harm to their face and the blood covering them. When we talk about a gruesome murder, I don't think we've seen much more gruesome than this. As you're listening to this prosecution's closing argument in the guilty phase of this trial, how do you think this case is going thus far for the prosecution?
I think it's going very, very well for the prosecution. I think that they've been able to present a case that is really hard for the defense to overcome. You know, you have this professional ball player who used a baseball bat to beat the heads of his father, brother, and an innocent person, the ADT installer. You know, it's absolutely horrendous. And not only that, the defense tries to bring up a mental health defense, and they don't even bring any evidence to justify or to support it. So I think that the prosecution here is going to end up with a slam dunk when it comes to the sentencing phase.
Yeah, this is definitely a slam dunk on a 3-foot net, as I often say. I do think that this is strictly a mental health or mental disease and defect defense here. After the guilt or innocent phase, I believe they're going to go to the sentencing phase, and they may put on some evidence for that. Mike, and Gina, I may ask you this after the break as well. Mike, this is where I think the defense is really going to get tripped up. Does he have mental health issues? Absolutely. Gets out of the facility after being 5150, 24 hours too early, declining mental ability over the course of his years after leaving the Tampa Bay Rays. But the fact that he stole the ADT's vehicle, had the mindset to take the keys out of his pocket, get in the car, and escape, that I think is going to be a hurdle the defense has to overcome to show that he's not mentally insane at the time or close to the time of the killing. How do you think that might work out for the defense?
I tend to think that that's a little bit on bordering irrelevant, quite frankly, because obviously people with mental disorders function daily. They do the things, they drive cars, they go to places, they do things of that nature. But whether or not they really form the requisite or understand what their actions do is of a is of the enormous question here. I mean, it's not a question of whether he killed these people or not. I think the defense needs to put forth more mental health experts to explain this. I mean, factually, just by what we know on the timeline, is this is a young man who shouldn't have been out. He was a danger to the community. The mental health facility was warned by the family, and yet he was released. This is a very complicated case from a sentencing perspective, not from a trial perspective, but for what is the just sentence. I think it's very complicated and intricate.
All right, we're going to take a quick break, and when we come back, we're going to look at the defense's closing arguments and talk about whether or not it's ethical that the prosecution actually has the death penalty on the table, and what, if anything, the defense can argue that he does have a mental disease or defect and should not be put to death. More after this. All right, so as always, the prosecution goes up and they do their closing arguments, and the defense for Brandon William Martin did the same. And this was their defense in their closing arguments.
Question number one, am I convinced beyond a reasonable doubt that Brandon Martin committed these acts? Number one, at the outset, there is no direct evidence that Brandon Martin committed these crimes. There are no witnesses. There is no statement from him saying he did it. Therefore, you must rely on the circumstantial evidence. And in order to do that, you must evaluate the circumstances surrounding these events. So let's do that. Number one, when you look at the circumstances surrounding these events, the first thing that jumps out to you is there is no physical evidence linking Brandon Martin to these crimes. Specifically, the murder weapon, the bat. There is nothing that puts that bat in Brandon Martin's hands on that day in September 2015. There are no fingerprints. There is no DNA. There is nothing linking Brandon Martin to that bat on that day. Second, when Brandon was arrested, his clothing, you can imagine it was processed. And what are they looking for? What would you look for? You don't have to be a forensic scientist. What would you look for after Brandon was arrested? Blood, right? You look to see, is there blood? Because we've all seen these crime scenes. We're all familiar with head injuries. What do head injuries do? They bleed. And if there's any question about that, the photos of the crime scenes answer that question. There's a significant amount of blood in that living room, in that kitchen area, and in that garage. Yet miraculously, none of it is on the clothing of Brandon Martin. Folks, he had no motive to commit this crime because that was his entire life. The only thing he had was his family. Why would he destroy the only thing in his life that is stable? Why? There's absolutely no reason for that. When asked by Detective Gottfried what he likes, one of his answers was he likes not being alone. Now, I can hear you, or I hear you thinking, I can see the wheels turning and saying, okay, Jensen, if Brandon Martin didn't do this, who did? I don't know. And more importantly, for the purposes of your job, you don't care. You will hear a lot of people say, oh, a trial is a search for the truth. No, it is not. We're not here to determine what happened. A trial is an accusation brought by the prosecutor. And then the prosecutor puts on evidence in order to establish that accusation, to convince you beyond a reasonable doubt. And it's your job to determine whether the prosecutor has, in fact, established that accusation beyond a reasonable doubt. It is not your job to determine the truth. It is not your job to find out what happened. So that question of, well, if he didn't do it, who did? That's irrelevant. The question is, has it been proven to you beyond a reasonable doubt that Brandon Martin committed the crime? That's the only question. Don't get caught up in that.
Trial, not a search for the truth. Gene Rossi, I'm writing it down. I'm putting it in my closing argument book. I mean, that's a powerful statement. Gene, what do you make of that, especially in this case where he's pretty much pointing out, show me my client did it. Show me the blood on his clothes. You recovered the ADT technician's vehicle. Show me the blood in the car. Show me it's my client. What do you think of that argument?
Well, since we've been talking about movies, Animal House, let's talk about the color of money. Show me the money, Tom Cruise, okay? Show me the evidence that links my guy to that baseball bat. Now, I got to tell you this. I didn't like that baseball bat comment because if I'm the prosecutor on rebuttal, I will hold up the photo of him in a baseball uniform. This links the defendant to the baseball bat on that day. I don't know if I would have said that, but going back to, it's not your job to figure out who did it. You're to figure out whether they proved my client did it. And I thought that was a good argument. Closing arguments of defense, I was a prosecutor, now I'm a defense attorney. It's like poker. You're dealt a hand and you play it the best you can. And this defense attorney is doing the best he can with the horrible hand that is dealt him.
I mean, I am man enough to admit, Mike Koribanics, that I thought this was a done deal. I thought this was a case where we're simply talking about whether or not he's going to be put to death in the sentencing phase. But this closing argument is making me think that this defense attorney can reach deep, deep, deep down and pull this case out of the trenches and maybe at least give it a chance. I mean, he's at bat, two strikes, 3 balls. Is he going to hit it? What do you think?
Well, everybody always sounds good in snippets. And when we hear snippets without all the evidence, the one thing I'm concerned about, if I'm the defense attorney, and I thought he did a great job in his summation, but I don't know in California if they get rebuttal in a state case or not. But if I'm the prosecutor, I would ask for rebuttal when he made the comment that his client didn't admit to it, or he commented on something we as defense attorneys like to stay away from, our client's constitutional right to remain silent. I think he may have opened the door for rebuttal, and I don't know what the file holds, but I think now the state could say, yeah, he didn't say anything. We asked him a bunch of times, but he didn't say anything. I think that might have been, I thought he did a great job in the summation, but I think that might have been an opening the door for a very harmful legal issue.
Mike Koribanics might not know the laws in California, but his instincts are correct. In California, you do have the ability to rebut, and they did choose to rebut. We don't have the ability to show it to you right now, but Gigi, what do you think that rebuttal would look like? You open that door to that great, the trial is not a search for truth. They didn't prove this. I think the prosecution can just drive a Mack truck down that road and maybe have some strong arguments. What do you anticipate might come from a rebuttal like that?
They're going to drive down the circumstantial evidence. You know, I think that Gene made a really great point. If I was the prosecutor in this case and you're trying to tell me that this person didn't commit this crime with a baseball bat, I'm going to show you a picture of the defendant with a baseball bat, and I'm going to tell you that this guy knows how to wield one, and if anybody can bash anybody's brains in, it's this guy. So I think that a rebuttal for the prosecution would open up the door for a lot of harm for the defense. But I think the defense did a great job with their closing argument and did a really good job at holding the state accountable for holding the burden to prove this beyond a reasonable doubt.
All right, so we don't have much time. Gene, this is more of a question for me. I'm the baby defense attorney here. In my mind, I look at this and I think Martin could swing a bat a whole lot harder than Brian Buckmire because he's a professional athlete. Do you think you go down that path of saying, if my professional athlete client did this, the damage would have been far worse than this? This is someone else. Do you think that's a good argument, or you stay away from it?
I would stay away from that. It's the third rail. Absolutely stay away from that. And I got to tell you this. Mike brought up a good point. There's a famous case called Griffin versus California, Justice Douglas, 1960s, where a prosecutor before that case could comment on the failure of a defendant to take the stand and defend himself. So Mike brought up an outstanding point. Did they open the door to allow the prosecutor to explain that he really did have an opportunity to say something and he chose not to? Very good legal point.
All right. Well, Mike brings up good points. Gigi and Gene help us out with more. Gene Rossi, Mike Koribanics, wow, Gigi Gonzalez, sorry about that, guys. Thank you for joining us. Always a pleasure to have you on. Great friends, great guests, and leading us in this discussion of legal expertise in all these different cases. Now, they did have a rebuttal, and if you want to find out more about that, you got to follow us here at the Law and Crime Trial Network. I'm Brian Buckmire signing off for now, but we got a regular scheduled program after this. We'll see you next time.